Welcome to Legally Speaking with me, Tarun Nangia. Recently, we heard this news that billions of dollars of investment from Japan is flowing into India. Such is also the news from other countries. A lot of companies and corporates from all over the world are looking at India as a big market. Of course, because of our demography, we have the largest number of young people in the world, and with a sizable 250, 275 million people who are the middle class. And that is why we become a market for these companies. What are these companies looking for? Faster disposal of cases in case there are any hiccups, in case there is a dispute. And that becomes the most important cornerstone on which they base their investments. Because there have been innumerable examples of smaller companies, mid-sized companies withdrawing out of the country if they can't get their legal tangles solved in time. And there are innumerable cases which we won't go into. But today we're going to discuss a topic that is key to India's development. How to ensure that cases and contractual disputes are solved faster to encourage foreign direct investment into India. That is what you would have seen many people in the government also speaking. Since 2014, many ministers have also said that, if court cases are solved faster, then it can aid foreign direct investment. And I remember we had taken up this issue, I think last year, Mr. Karanjawala was there when he had spoken on this. We spoke of an economic amicus curiae, if you remember, you had put that point long ago. But let me introduce you to my panel first. May I welcome Justice Arjun Kumar Sikri. He served as Judge of Supreme Court of India. He is currently Judge of Singapore International Commercial Court, and he's a very well-known and renowned arbitrator in national and international arbitrations. Welcome, sir. May I welcome Ryan Karanjawala. He's managing partner of Karanjawala and Company, one of India's leading litigation law firms. May I welcome Mahesh Agarwal. He's managing partner of Agarwal and Company. He's one of India's Agarwal Law Associates. I should correct myself, one of India's leading litigation law firms. I would like to welcome Senior Advocate Parag Tripathi. I guess he needs no introduction. Any top corporate matter, and you can find his name there. In the Supreme Court and many times also in the Delhi High Court. Good to see you again, and looking forward to some interesting inputs from you today. May I also welcome a new entrant to the Legally Speaking Club. We have Rohan Shah, joins us from Bombay. He's a counsel at the Delhi High Court, at the Bombay High Court and the Supreme Court of India. Welcome, Mr. Rohan Shah, and looking forward to some interesting inputs from you. So let us start. And may I request at the outset, in about 3 minutes or so, 2.5 minutes, if Mr. Rohan Shah can share with us what is this idea about, in a sense, how can faster disposal of cases happen? Because you've handled things on the corporate side in your legal career. Also now you're a counsel on the legal side. Can you share, and then we move ahead?
Thank you. I think 3 important events have come together over the last few months. The one situation is investment into foreign destinations. Typically was the story of the BRICS, Brazil, Russia, India, and China. And over the last year, for very apparent reasons, China and Russia have just not been the flavor. And I cannot see them being the flavor of the investment community for a long time. So A, we have that opportunity. B, we have what we know is an unprecedented domestic crisis in terms of the unemployed but educated young people in this country, and for which we need both the foreign and direct domestic investment. And lastly, I think we have the learnings of the COVID in terms of the justice delivery system and in terms of the conduct of courts, virtual hearings, etc. I think these 3 factors bring us to the issue of, if we aspire to be the 5 trillion economy that we want to be, justice delivery is certainly going to be one of the key issues. Currently, we are 162 on the World Bank index. If we see what is the number 1 country, it's Singapore. And their process from the time of a filing to a time of enforcement is 164 days. China is number 5, and their process takes 485 days. So the challenge we have is that if we can get the process of filing, the whole trial and judgment and enforcement within 450 days, we are really in the top 5 in the world. And the one comment that I most recurrently had in my former avatar, doing lots of corporate transactions before I took on the counsel role, was there is a very high respect internationally for the quality of Indian judges and the quality of Indian jurisprudence. The disappointment is really in the time that it takes. And we had our experiment with the commercial courts. I don't think as a principle and an approach, it could be faulted, but we know that it hasn't delivered what it should have. And I think Justice Ramanna very prettily and insightfully put it very recently, that just by rebranding normal courts as commercial courts, we are not going to gain the efficiency. What is lacking is the infrastructure. What is lacking is the number of judges, the way in which we run their roster, and the factor that there is a certain discipline in terms of time frame, which really is the discipline that both the bar and the judiciary together need to be able to follow. But I think if these factors came together, this is a moment in time that we can seize. And what is this great respect for Indian judiciary? If it can be translated also into respect for the efficiency of the time frame of the delivery system, I think we have a unique opportunity.
Thank you. Thank you so much for setting the tone. I will go to Senior Advocate Parag Tripathi. Sir, you appear in one of the top commercial cases in the Supreme Court of India on a regular basis. And you understand the concerns of businessmen. So from that aspect, if you could look at this issue and share what could be done.
You see, the principal concern of a foreign investor is that, one, most important, his investment should be safe. Two, it should be a good investment. And three, it should not be an investment which embarrasses him. For instance, if he were to invest in Russia or China today, there's an element of the embarrassment value, which he doesn't want there. Now, for it to be safe and it to be good, for it to be safe, what is required are a whole slew of measures. You need, for instance, the FDI regime should be responsive to the needs of a foreign investor. There should be high rates of, the tariff rate shouldn't be high. Decision-making authority should lie with focused, pinpointed accuracy, particularly with state governments. Then you have the problem of liberalized exit barriers. You have the problem of stringent labor laws, financial sector reform. There's a whole series of them. Most important in that lot, or very important in that lot high up, is how quickly can you get justice if all other efforts at settling a dispute break. Now, a large part of it has been dealt with by foreign investors by having arbitration clauses, which typically keep Indian arbitral process out, and they go for either SEAC or ICC or what have you. So that goes out of the Indian kitty, as it were. It is only when the litigation is with government agencies, taxes, labor laws, etc., that litigation comes here, typically in the form of writs. So I don't think it's really so much commercial disputes which go to courts, which is a problem. It is how to catch commercial disputes which will come to Indian arbitral tribunals, to tribunals which are typically Indian tribunals. Now, for that, you have to create that level of confidence, which we have. We have the most outstanding availability of top arbitrators of an excellent bar. But our problem is that we don't seem to put it together when it comes to meeting timeframes. That is, I think, our main problem. If you look at the Commercial Courts Act, actually, Rohan talked about it. Commercial Courts Act, when it deals with commercial disputes, has enough reference there to include foreign direct investment, not directly, but indirectly, joint venture agreement, shareholder agreement, technology development agreement, commercial disputes, so and so. So the problem is that we as a nation and the judicial system, which means basically the lawyers and of course the judges, have to realize that there has to be speed in disposal. And I think really it's the bar which has to put its act together, because we keep on coming and asking for adjournments endlessly. So we have to realize that if you are adjourning a matter beyond a point in time, then you're losing that that particular investor or that particular client, and you are eroding his faith in the system. So it has to be a larger perspective. You can't just have a sectoral reform that have a special court, that special court will deal with it. I think that goes only that far. What you need is a complete reform, a complete change in thinking, where you take it, like for instance, in an international arbitration, Ryan, Rohan, Mahesh would know, and Justice Sikri would know as an arbitrator, that once a date is given, the date is given. That's it. It's like it's written in stone. I remember that in one case, my clients wrote to the ICC tribunal that I am in hospital, I am having a transplant, and I am having this, etc. Please adjourn the date. So they said, we are very sorry to hear you're not well, but rest assured we'll go ahead with the hearing. Now, that may be an extreme view, but that is how international tribunals function, because once a date is given, that it's like a juggernaut. It has to go on. That is something we particularly at the bar have to catch on to. Once we catch on to that once a date is given, it will be decided. I think then you really may not need special courts, because they may not by themselves be an answer, because that's what we did with our tribunalization. That's what we are doing with our special courts. We keep on coming up with newer, smaller versions to hope that that will work. No, you need an approach change. And unless you have that change in approach, it's the same people who will be in that court, it's the same people who will argue there. So unless you have a change in approach, I don't think we'll be able to really exploit the great potential which is now available, thanks to what's happening around us in China and Russia.
Thank you so much for that input. And when you said tribunals, I remembered now even NCLT cases have crossed in the many thousands. I think it's more than 4,000 now. So NCLT is ending up becoming a problem, but that is for another day. I'll go to Mr. Ryan Karanjawala. You were in news, I think not too long ago, when the Tata Mystery battle was going on with a couple of lakh crores at stake. Now, I can understand the kind of pressure you must be under when those kind of cases go on, and they want faster resolution. So you are in the thick of action as far as corporates are concerned. Tell me, this is just one angle, but if you look at smaller corporates with a couple of 100 or barely 1,000 crores and not too much money, if that dispute takes time, then they can't even afford it. Could you give us a macro and a micro picture, and how do we move ahead?
So first, I'll just point out that Mahesh was equally under strain in the Tata Mystery matter because he was on the other side. And both of us were there on one side and the other. Now, as far as, see, Tarun, the first thing you have to understand is that no government and certainly no legislature can tell a court when to decide a matter and with what rapidity. This is something that a court will have to sort of work out for itself. So it's very difficult to have a segregated set of courts, which here matters in a certain type of matter in an expedited way. The reason is this, that there is also an underlying political message. The whole legal system, in a sense, is fraught with delays and hindrances to the litigant getting justice. Now you're coming forward and saying, by way of either a legislation or a protocol, that if two rich people come to court and fight over a large sum of money, then their matter should be heard expeditiously. That's, in a sense, fundamentally what you're saying when you're putting a special court hearing a matter about, say, 250 crores in that kind of domain. That would be very difficult in practice, according to me, to actually implement. And it's also the wrong kind of political messaging that any government would want to give its litigating public. What I think is the real solution is what Parag mentioned. You just have to bodily somehow replicate the international arbitral process in India.
Yes.
You'll have to create a separate arbitral process which is so robust and filled with so many good judges and so many good lawyers that cases of high value dispute can be heard in an expeditious way. And over a period of time, as Parag also rightly pointed out, it's something that will require a sort of a joint effort. Lawyers will have to say, all right, now I'm in this case, I will make first of all, the arbitrator will have to say, my board is fixed in stone. You're not going to get an adjournment unless there's something really drastic happening. So the lawyer on the other side also realizes that then he has to make himself available. So over a period of time, then you'll have a set of lawyers who essentially relegate their time to the arbitral process. Only then will you come to reaching the kind of practice that is practiced internationally in Hong Kong, Singapore, London, America. And that is something that I think we have to strive for. Rohan was absolutely right when Rohan said that, look, one of the things that worries people when they're investing large sums of money in India is that if they get caught in a bad deal, then the difficulty in extricating gets worse because of the litigating system. So you have to find, and he's rightly pointed, that you have to find a solution. I think the easiest, the quickest, and the most practical solution is to try and somehow replicate the practice of international arbitration in India. We have the manpower. We certainly have the number of lawyers. We have the judge power. There's a lot of judges who are retired at a fairly young and robust age, well experienced. A lot of them can give their time for arbitrations and slowly take away what would otherwise be a burden on the court. That's how I look at it.
Now you act for be it the Birlas, Adanis, or as Mr. Karanjawala pointed in the Tata matter, you are for the Shapoorji Pallonji group or the Mistries. So you are in the thick of action at the Supreme Court, at the Delhi High Court and other forums. If you could tell me what kind of pressure you go under and how much yearning you have for that change, because in the end, the pressure is on you as a law firm to deliver and you can't control much in the courts. What needs to be changed?
See, I'll tell you what starts with the legislative intent. The government of the day from the year 2014 has come out with repeated legislations recognizing that early resolution of commercial disputes is critical for investment. We have the Commercial Courts Act. In the Arbitration Conciliation Amendment Act, the time period prescribed is 365 days. In the Insolvency Bankruptcy Code, it is provided that resolution should take place in 180 days plus another 90 days. In the NGT Act, various acts, there is a provision. But what is happening is, although the legislative intent is there, the impact in the courts is not there. Now, insofar as arbitration is concerned, I think the processes are robust. Their new act provides for all the systems. And I would feel that the current day arbitrations are being done expeditiously. I won't say they're too delayed. What is happening is what happens thereafter. There is a huge difference in what we discuss in seminars and conferences outside the court and what happens in the court. The same judges who are in the court in a seminar would say there should be minimum judicial interference, awards should be respected, they should be enforced. But once an award comes to court, an arbitration will take 1 year, but the adjudication of the award and enforcement will take 10 years. So there has to be some measure of checks and balances at that level. Now, what that could be, there are balances to be done. There may be cases where the award is right or wrong. There have to be balances, but there has to be a critical check at the post-award stage. Now, what can that be? I feel one way could be that there should be some unwritten rule that when a court admits an appeal from an award, there have to be reasons given. Like we have in the first appeal system, that there has to be reasons as to why they are admitting a challenge to an award. Today, you go to the court, you file a challenge, it says admit, notice, admit, list after 3 months. And then the pleadings, reply, rejoinder start. There has to be a check at the stage of admission as to whether an award requires to be interfered with. That's the first level. Second level of checking could be that if a party has gone through the arbitration, then at the stage of admission itself, there should be a partial enforcement. If the court feels that broadly the award is fine, you should balance the rights, enforce the award. The person who has gone to arbitration to make a claim gets the fruit of the arbitration award at the first instance, rather than waiting right up to the Supreme Court. So we have to synchronize what happens in the seminars and what happens in the courts. That's a very critical aspect. So therefore, I mean, we keep blaming that arbitrations are taking time. The arbitration process is faulty. I don't think there is any such thing. The arbitrations are going on very well. There is a time limit in 1 or 2 years, arbitrations are getting over. But what is happening is what happens post-award. That is very critical.
That's a very important, what happens post-arbitration. And I go to Justice Arjun Kumar Sikri for 2 things. A, he's one of India's busiest arbitrators. That's what we hear all the time. And even for this show, I know how much I had to request him to wriggle his time and schedule. But I will want to ask you, sir, two things. You have heard all the counsels and the law firm managing partners. Where do we go from here? Because so much money coming into India and all looking that even if I am implementing, say, a road contract and there are 4 disputes on the way, the work should go on and arbitration should ensure that parallelly those disputes are resolved in a month or 2 so that work just goes on without any problem and payments can come through. In about 2 to 3 minutes or 4 minutes, can you share your, in a sense, idea with us?
Yeah, thank you, Tarun. I think all these eminent speakers have already laid the roadmap. What ultimately Mahesh said is to be kept in mind. Of course, when it comes to resolution of disputes, as was told by Parag, every investor, because we are talking about faster disposal of cases to encourage foreign direct investment in India, and Rohan said that it is the best time for India and where FDI can come, but at the same time we have to instill the confidence in the investors also about their safe investment, and it is an investment in a good country and a good environment, and it will yield the results, and whenever they want it back, they are able to take it back. So that is what, and in the context they talked about because disputes do arise. FDI may be not only in the form of capital, but it may be in the form of transferring the technology also. We have those kinds of collaboration agreements by which the technology is given by, say, German company to Indian company, and the disputes may arise, either IPR disputes or other kinds of disputes may arise out of that. And most of the time, we have to keep in mind, first thing, what the business community or what the investor wants in these things whenever there are disputes. As is already pointed out, they want early resolution of those disputes, that they should not get stuck. And whatever is going to be the fate of that dispute, that should be known to them. And nowadays, particularly, as you also mentioned about the infrastructure projects, etc. And the parties, even if the dispute has arisen, the party wants to continue the business relationship at the same time.
Yes,
that the contract should be performed, it should be taken to its logical end and execution end, which is good for the country as well. So in this process, as was rightly pointed out by Rohan, Parag, and Ryan, that we have to improve to some extent our arbitration system, and we should imbibe some of the qualities or some of the ingredients which we see in international arbitration, and we should have it here. And I would say that still what Mahesh said is also correct. Maybe in the conduct of arbitration, there may not be much of a problem in view of section, and when it is domestic arbitration, section 29A, which in any case says that arbitrator has to decide within 1 year and 6 months pleading, so 1.5 years in any case. When it comes to international arbitrations, in any case, that maybe that kind of time limit is not mentioned and it is not prescribed, but then those arbitrations are conducted on international basis, and most of the time they would be institutional arbitration where these things would be taken care of. And therefore the main problem we have to, when we talk of faster disposal of cases, it is not only the arbitration award, but enforcement of that award as well, which Mahesh said. And at that time, the matter has to go to court.
Yes.
So therefore, we can't be satisfied with this, that, okay, ADR, arbitration, and that's the end of the matter. In any case, any arbitration system itself is a hybrid system. And enforcement stage has to be, now one has to leave it to the court only. And therefore, in that sense, how the courts should function in this process, that has to be kept in mind. Parag mentioned 2 or 3 things in this behalf, very rightly so, about the time management and no unnecessary adjournment. Although he said in the context of arbitration, but that applies to court cases as well.
Yes, yes.
So therefore, what I feel is having a special benches for commercial cases may help. There's no doubt about it. So we should have. A point well taken, which Ryan said, that look, that doesn't mean if the cases involve higher stakes, those should be decided, and those other cases should be languished, because in a judicial system, all cases are to be given due care. But then commercial courts are set up. I give you the example of Singapore. Now, Singapore has three institutions of international repute which take care. They have the Singapore International Arbitration Center, that is to take care of arbitration. They have Singapore International Commercial Courts, like our courts, but they are dealing with international commercial issues. So therefore, even from SIAC awards, when this is challenged, like we have Section 34 under the Act, so if that is challenged, that is taken up by SICC, and which functions on in a very, I would say, in an efficient manner and on a very professional basis. What we need is, from my experience I have seen, and first let me tell, the third is SIMC, Singapore International Mediation Center. So which takes care of this mediation and alternate dispute, apart from arbitration, mediation. So this trinity, this kind of system we should have, all the three systems efficient. So therefore, like in Delhi, we have commercial court, and under the Commercial Court Act, when the award is passed, that also goes there. But then what we need is, if I give you an example, I had gone to America about their court management and case management system. We had seen, I was in Delhi High Court in 2005, 2006, we had visited there. And they had court, this case management, like the engineers a bar chart when a building is to be constructed, how much time each step would take. I tell you, and I told them, and they all agreed, we were 4 or 5 judges, that we have same system in our CPC. If you read Civil Procedure Code and read with now Commercial Code, that is there, but we don't follow. That's the only problem. And liberally adjournments are given. Let me tell you another anecdote also on time management when it comes to, and I keep telling the lawyers, and particularly I tell the students, whenever I go for moot court competition to judge, they are given 35 to 40 minutes in which they have to argue their case as a moot court lawyer. And the problems given to them are also very complex. But the two things which stand out, that when they prepare the memorials, which are given to the judges, their written submissions, which they call memorials, they are excellently prepared. This is what we see in international arbitrations as well. And secondly, they are able to convey everything in 40 minutes. If as a student of law, you can convey in 40 minutes everything, why our lawyers in the court needs 10 days or 12 days or maybe months together to say. So therefore, Parag, I agree what you are saying, but then this has to be inculcated, this habit that this time management should be given. And I tell you, in few cases which I have done in SICC, appeals also, when appeals go in the appeal court, I sat, and at the original site also, that the case management hearing is held, which is held by the arbitrators also, but in our courts, we don't do that. And every step is chalked out how you would do it. And many complex appeals also were finished in 1 day's time. With good memorial and good written arguments given, judges come after reading everything. So therefore, these are some of the things which need to be done, even at a judicial level, in order to ensure that the enforcement of awards which are given doesn't get delayed.
Thank you so much for that elaborate, in a sense, explanation that you shared with us. Specifically, 2 points that came out of this discussion, that how much time each step should take in terms of disposal of matter, and secondly, how arbitral appeals against an arbitration can be decided faster. We will take up in part 2. But indeed, a very valuable set of inputs in this part one. May I thank Justice Arjun Kumar Sikri, also Senior Advocate Parag Tripathi, Ryan Karanjawala, Managing Partner of Karanjawala and Company, Mahesh Agarwal, Managing Partner of Agarwal Law Associates, Advocate Rohan Shah, for all the valuable inputs. And thank you so much, viewers, for joining us. This was end of part one. In part two, we take forward the discussion and how faster disposal of cases will ensure that we have, in a sense, a large supply of FDI, which we need for the next 2 decades continuously to, in a sense, satisfy the hunger of employment that India has. Thank you so very much. Thank you.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.